Good morning, ladies and gentlemen. I welcome our worthy speaker of today's webinar, Shri Manish Tewari ji. I also welcome our principal ma'am, Dr. Simrat Kaur ji, our HOD, Dr. Joginder Paul sir, faculty member of different institutions, member of legal fraternity, my worthy colleague and dear students. I feel privileged to introduce our speaker, Shri Manish Tewari ji. He is a practicing lawyer in Supreme Court of India. He is the member of Indian Parliament Lok Sabha from Shri Anandpur Sahib Parliamentary Constituency, Punjab from 2019. Besides, he is also a member of Parliamentary Standing Committee on Finance. He was the Union Minister of Information and Broadcasting, Government of India. On behalf of Govt Mohindra College, Patiala, I once more extend a heartiest welcome to you, sir. Now I request Shri Manish Tewari ji to please carry on his envisioning talk. Shri Manish Tewari ji.
Good morning, ladies and gentlemen. May I thank the principal of Mohindra College, Patiala, which was the alma mater of both my parents, late Dr. V.N. Tewari and Dr. Mrs. Amrit Tewari, for inviting me to this webinar. May I also take the opportunity of thanking Professor Jagmohan Singh, who is now a member of the Punjab and Haryana High Court Bar Association and is a practicing lawyer, for giving me an opportunity to interact with all these bright and ignited minds who are currently pursuing their studies in the field of law in this august institution. Professor Jagmohan Singh reached out to me to instruct me to talk to all of you with regard to the entire question of bail and how the jurisprudence of bail has evolved and where do we currently stand on the question of bail as it has evolved over the years. If you were to go back into history, the earliest enunciation of certain principles with regard to the relationship between the ruler and the ruled were established in the Magna Carta Charter in 1250. It was in that charter that an attempt was first made to lay down the fundamental principles or the ground rules governing the relationship between the ruler and the ruled. Before the advent of Magna Carta, the word of the ruler was law, and therefore it really depended on his whims and fancies as to whether he liked your face or not when he decided to administer a particular punishment. And that's why the adage really evolved, you show me the man and I'll show you the rule. As history and civilization evolved over a period of time, increasingly an assertive citizenry decided that kings and rulers, even though they may claim a divine right to rule, could not be capricious and could not be arbitrary when it came to dealing with their subjects / citizens. And therefore, during the era of enlightenment in Europe and followed by the Renaissance and then the industrial age, these principles slowly and gradually kept evolving. And as parliaments started getting established in these countries, parliaments then codified these precedents or these canons into statutes so that they would have the force of law behind them. And the principle of bail, in case you get arrested, also evolved in a similar fashion over the years. In fact, the earliest enunciations of this principle in the Indian context can be seen as far back as 1924 in the case of King Emperor versus, I don't recall the name from the top of my head, but it was a 1924 case followed by the Meerut conspiracy cases, where the Privy Council at that point in time laid down the principles of bail. But as we moved from the colonial era into more civilized times when India became independent, the founders of the Indian Constitution actually set out to give us a very enlightened and a very humane constitution that laid great stress on the protection and the preservation of individual rights. And that's why the entire chapter, chapter 3 of the Constitution, dealing with fundamental rights and the means in order to enforce that those fundamental rights through the issuance of writs, really forms the soul of the Indian Constitution. The triangle, the golden triangle of rights, Article 14, 19, and 21, lies at the core of the Indian Constitution, which protects the citizen from arbitrary state action or the capriciousness of a state which at some point in time decides to get drunk on both hubris and power. But and that's how the law really evolved till 1977, when the most clear enunciation of the principle of bail was made by the late Justice Krishna Iyer in the Rajasthan case, when he laid down that bail is the principle, or bail is the rule, and jail is the exception. In fact, I do not think that any judge has actually laid it out as clearly, as cogently, as crisply, and as clearly as Justice Krishna Iyer did in that seminal 1977 judgment, which preceded or which succeeded those unfortunate 20 months of emergency when fundamental rights were suspended in India. And therefore, drawing from that judgment, from about 1997 to the year 2000, judges by and large took a very liberal view when it came to granting bail. But something strangely flipped around the turn of the millennium, and especially our district judiciary, our subordinate courts, became extremely stingy when it came to granting bail. And unfortunately, over the past 2 decades, the legal system in India has completely and absolutely turned the principle of bail on its head, whereby bail has become the exception and jail has become the rule. And this is something very unfortunate because today the process has become the punishment. If unfortunately somebody is arrested by the state, the courts will not grant him bail for 2 years, 3 years, 4 years, depending upon the crime that he has been charged with. And every law student understands that a charge sheet is nothing else except the best appreciation of facts and circumstances and events as understood by a particular investigating officer. It has no more sanctity in law than a mere appreciation of facts or evidence which has been collected by an investigating officer. And therefore, ultimately, those facts or circumstances as enunciated in a charge sheet really have to stand the test of law. And our prosecutors and courts, unfortunately, seem to have taken the easy way out. You carry out a shoddy investigation and you present half-baked charge sheets in courts of law. And then because you have an extremely conservative judiciary, which is extremely reluctant and chary to grant somebody bail, even if the charge sheet has been filed and the investigation is completed, you essentially have incarcerated a person, kept him in jail uh, for a certain period of time, and then eventually, after a long trial, even if he is rendered innocent or even if he is exonerated, there is no process whereby he will get compensated for the time that he has wrongly spent in jail because a conservative judiciary refused to grant him bail. And unfortunately and concurrently, the law of torts has not evolved in this country, whereby exemplary damages can be claimed from the state in case of wrong incarceration. The latest uh, iteration of the bail law was in the case of Mr. Chidambaram, and the judgment was delivered by a bench of 3 judges headed by uh, Justice Bhanumati, who's retiring from the Supreme Court on the 29th of July. And the, 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 uh, the principles of bail were actually reiterated by her again. And I would just like to read 3 or 4 lines from that particular judgment. And I quote, "The jurisdiction to grant bail has to be exercised on the basis of well-settled principles having regard to the facts and circumstances of each case. The following factors are to be taken into consideration while considering an application for bail. 1, the nature of accusation and the severity of punishment in the case of conviction, and the nature of materials relied upon by the prosecution. 2, reasonable apprehension of tampering with the witnesses or apprehension of threat to the complainant or the witnesses. 3, reasonable possibility of securing the presence of the accused at the time of trial or the likelihood of his abscondence. 4, the character, behavior, and standing of the accused in the circumstances which are peculiar to the case. And 5, larger interest of public or the state and similar other considerations." Now, this 5 is extremely troubling, because this 5 turns the entire principle of innocent until you're proven guilty completely on its head. Because if you are to apply subjective considerations of what the public opinion wants or what the collective conscience of society wants, as was unfortunately enunciated by Justice Venkatram Reddy, otherwise a very good judge, in the Afzal Guru case, then we are up a slippery slope. And once we start slipping on that slope, there is absolutely no end at all. And I think that's the fundamental problem with the entire jurisprudence of bail as it stands concurrently interpreted from the year 2000 to 2020, that there has not been another judge like Krishna Iyer who has once again clearly, cogently enunciated that bail is the rule and jail is the exception in the case of India. And as long as a constitution bench of the Supreme Court does not enunciate that principle clearly once again, I'm afraid thousands and thousands of innocent people will remain incarcerated in our jails. And it is unfortunate that even at a point in time when the world is dealing with a pandemic called COVID-19, which ideally should be called the China virus because it's a lab-driven organism which has been unleashed on the world by China, our policymakers remain reluctant in order to decongest our jails and expose under trials who are innocent until proven guilty to the risk of contracting this virus, which can be fatal. And so therefore, with those words, let me stop there and I leave the floor open, and I'll be happy to answer whatever questions the audience has for me. Thank you very much.
Sir, the questions have already feeded to Mr. Manish Tewari ji. We have already supplied the questions.
Okay, let me deal with it one by one. The WhatsApp that I've received from Dr. Jagmohan Singh, the first question is, what should be the considerations of bail as per law? I think it is very well settled that bail is an act of discretion, and it really requires an enlightened application of the judicial mind, where the personal life and liberty of a person who is accused of an offense is concerned. And in my respectful opinion, the only three conditions which should really weigh with the judges when they decide as to whether to grant bail or not is: one, is there a possibility that the person who is enlarged on bail would flee the course of justice? B, would he tamper with the evidence, or would he try and influence the witnesses? And number three, is there a possibility of a grave miscarriage of justice, a very grave miscarriage of justice taking place, if at all bail is granted to an accused? And I think an expansive interpretation of these principles is really what is required at this point in time. And what we've really been having is a very narrow interpretation of these principles over the past 2 decades, which has effectively turned the cardinal principle of bail laid down by Justice Krishna Iyer in 1977, that bail, not jail, should be the rule. So therefore, that's what my humble opinion is. The second is what amendments you suggest in the law of bail. Well, I don't think there are any amendments required to the law as it currently stands constituted, whether it is section 439, which deals with anticipatory bail, or it is the section of the Criminal Procedure Code which deals with regular bail. As I was earlier pointing out, it not so much depends upon the rigors of the law, but the conviction of courage which a judge has when he appreciates the facts in front of him. First of all, I think it should be mandatory that once a charge sheet has been filed and investigations are over, then there should not be any reason why an accused should continue to be detained on bail. Unfortunately, what investigating agencies are doing is that while they'll file a charge sheet, they'll simultaneously file an investigation. That investigation is still going on. A supplementary charge sheet has to be filed, and so therefore the accused should remain incarcerated. And over the past 4 or 5 years, ever since the current NDA BJP government came into office, we have seen the evolution of a new jurisprudence. This new jurisprudence is sealed cover jurisprudence, that a sealed envelope is handed over to a judge whose contents are completely unknown to the defense or the defense counsel, who is absolutely in no position to rebut that. And those the contents of that the unsubstantiated verments made in that envelope, based upon some investigation which has been carried out, then becomes the guiding principle to decide as to bail should be granted or not. This was exactly what the Delhi High Court had done when it had refused bail to Mr. P. Chidambaram. And if you read Bhanumati's judgment in the delivered in the same matter on 4th of December 2019, the Supreme Court has deprecated this sealed cover jurisprudence and has said that resorting to this sealed cover jurisprudence tantamounts to a miscarriage of justice. So unfortunately, new and novel methods are being evolved by the state in order to keep people in jail, because they know that ultimately when a matter goes to trial, they will be completely and absolutely unable to prove their guilt, and therefore the process becomes the punishment. The third question is that grant of bail vis-a-vis Article 14. I think I've dealt with that at length. Article 21 lays down very clearly that no person can be deprived of his life or liberty except in accordance with the law, which is actually due process, the whole jurisprudence of due process, which is there in other jurisdictions. Coupled with that, there are concurrent provisions in the Constitution that no person will be compelled to give evidence against himself. And 14 very clearly says that all persons, not all citizens, but all persons will be treated equally before law. And therefore, under those circumstances, I think the principle, if you read the Golden Triangle of Rights, the Golden Triangle of Rights 14, 19, and 21 very clearly spell out that the courts need to walk the extra mile in order to balance between the imperatives of a crime-free society and the individual rights of a person. Well, right of bail under trials in COVID, I've already dealt with, that it's really a travesty that even at this point in time, when various high courts have given directions, we are still continuing to hold under trials or aged prisoners who can easily be released on parole in order to, let's say, spend their time in more safer environs during the COVID-19 pandemic. Because while the state has a right to enforce punishment, but a state does not have a right to give a punishment beyond what is being already given by the courts of law, and keeping people in confined spaces in unhygienic conditions, what our jails really are, is actually giving them punishment beyond what the courts have really handed down. And these are really the 4 questions that Professor Jagmohan Singh had sent to me, which I've answered. If there are any other questions, I'll be more than willing to answer them, or otherwise we can close.
Sir, I have one question, sir.
The chat box.
Hello, sir.
Yes, please
Hello.
go ahead. Please
Sir, I
identify.
have one question.
Please identify yourself, because I can't see everybody. So please
Sir,
identify.
myself is Professor Jagmohan Singh.
Uh-huh.
I have one question. Sir, in what way we can draw the thin line between judicial discretion and judicial arbitrariness? Hello?
I have heard the question, Professor, and the answer is very simple. You require better training of judges. You see, unfortunately, when a matter comes up for bail, the first thing which a lawyer will tell his client is that this particular judge, whether he is pro-prosecution or he has a more liberal approach. And unfortunately, what we are seeing in our judicial system is that the number of judges who tend to be conservative on the question of bail have unfortunately been increasing over a period of time. And that is primarily because there is also a specter of fear which has been created, a specter of paranoia that even if I grant bail for all the right reasons, it should not be that tomorrow somebody can point a finger at me wrongly, that there are certain extraneous considerations involved. So I think what you require is judges with more conviction of courage to do the right thing and not really be concerned about what the corridor talk in a court is all about.
Sir, I want to know about the FIRs regarding some journalist Arnald Goswami and Mr. Vinod Dua, and the some conservative kind of approach to grant them bail.
Well, I think in one case, the court has been extremely liberal, and in another case, the court has been extremely conservative. So therefore, that's what I'm saying, that unfortunately, 1975 to 77 marked the low point of the Indian judiciary. ADM Jabalpur was a blot on the collective consciousness of the judiciary, whereby the court held that if an emergency is promulgated, even fundamental rights will be suspended. Unfortunately, and I say this with great regret, I do not think that the judiciary has acquitted itself very well over the past few months, especially during the period of COVID-19. At some point in time in Parliament, if there is a discussion on the judiciary, there will be a lot to say. But suffice to say that the judiciary is the last bastion of hope for the citizens. And one of the reasons why there is judicial activism in India is because the first two frontiers of justice have collapsed. The legislature has made a complete joke of itself. The executive believes in passing the buck. And so therefore, for the helpless citizen, there is nothing else left but to go and knock the doors of the judiciary. And unfortunately, if the judiciary was also to collapse, and the judiciary was to be seen as an extension counter of the law ministry, then all hope would be lost for the 124 crore people in this country. There is a need to rebuild our institutions of governance. I think as a democracy, where we have failed is to build resilient institutions which can speak truth to power and be able to withstand state capriciousness. You've seen as to how a particular election commissioner, who took a view which was unpopular with the current dispensation, has unfortunately been hounded over the past couple of months. And now, despite the fact that he was in line to be the chief election commissioner, he's been shunted off to the Asian Development Bank. So there is a real crisis of institutions in this country, and any democracy is as weak or strong as the institutions which support it. And if you have a collapse of institutions, and we saw that in the case of Punjab, unfortunately, during the dark days of militancy and terror, and we are still dealing with the implications of some of that high-handedness even today as we speak. The citizen becomes the first casualty. You see, the state has immense powers. And I think those powers were on display during this COVID-19 pandemic also, when a beat constable felt that he had become God incarnate, and the manner in which young children were beaten up in different parts of the country for violating the curfew is symptomatic of how the executive views its role when it is given unbridled authority. So therefore, we should thank God that we have a democratic system which can rein in these babus, because you've seen during COVID-19 that when this bureaucracy is left to itself, how arrogant and how completely unaccountable it can become.
Thank you very much, sir. I personally indebted to you for your kind cooperation in this virtual session. Being a coordinator of this virtual session on the behalf of the college principal, the faculty of law, and the members registered who participated in this virtual session, I thank you very much for this incisive discussion and discourse. And we are going to organize another seminar on custodial desks, and I seek your cooperation in that seminar also. Thank you very much, sir.